Good morning and good evening, colleagues and friends. Welcome to the board lunch of the Faculty of Law. It has been a very busy year for us. Colleagues here, for one reason or another, have produced quite lots of books for us to promote. My name is Fu Hualin. I'm the Dean of the Faculty of Law. It is my great honor today to chair the seminar in Nanjing, Professor He Xin's new book, Divorce in China, Institutional Constraints and Gendered Outcomes. So here's the book. If you contact He Xin, you would get, I don't know, 75 discount. So I hope the seminar will be very good for the promotion. The book is has been published by the NYU Press. She is well known to all of us as a leading scholar in social legal studies with a focus on Chinese courts as a site of contention. His publication record in leading social legal journals, I think, is unmatched, and I doubt anyone can break his record of publication that he has set. So the quality and the quantity of his scholarship is truly exemplary, and he has set a bar that is so high that it's difficult for us to really follow. We also have a very impressive panel of discussion. I don't think it is an exaggeration to say that we have a dream panel on quantitative Chinese legal studies. In the order of presentation, so first we have Professor Sida Liu. Sida is a associate professor of sociology and law at the University of Toronto. He is authority on profession, legal profession in particular, and he has produced some of the best writings on Chinese lawyers. And the second discussant is Dr. Benjamin Chen. Young Benjamin is our rising star. He has a very fascinating educational background. He's trained in Romance language, literature, economics, mathematics, philosophy, and finally, law. He has been writing on Chinese courts using big data, and we're looking forward to his books in the future. The third discussant is Professor Kui Ng, is professor of sociology at UC San Diego. Professor Ng has worked with Professor He Xin for many years, and together they have produced some of the best interdisciplinary scholarship on Chinese courts in particular. Proudly, Professor Ng is from and educated, was from educated in Hong Kong, with I think a BA in journalism from the Chinese University of Hong Kong. So this is what we're going to do. Well, first, we invite the author to say, to make an opening speech on his book, probably within about 5 to 10 minutes, and then we will go to the panelists for their inputs. We have enough time this morning, this evening, so hopefully, I'm sure we will have a lively discussion on this significant book. So without further ado, Xian, the floor is yours.
Thank you. Thank you, Dean Fu, for these very generous words, and also for organizing this. So so the book has my my name only, but actually it's truly a collaborative work. So Harling asked me to talk about only 5 to 10 minutes, but I don't know if that's enough for me to give thanks, you know, because it's such a long journey and such a long list. As I mentioned somewhere in the book, so it is started like 15 or 14 years ago when I just first encountered a judge in Guangdong province. And back then I was doing something else, right? So basically it's about debt collection in the Pearl Delta, right? So then that judge just came over to me to have a chat, and then he complained about legal education in China. And then he basically said, okay, so what were taught as a law student has nothing to do with what we are actually practice in the court, right? And then he gave me this example about divorce law, right? So just show me, like, I mean, at the first time, the divorce petition are often rejected. So I was stunned by what I heard, and then think this is just fascinating thing and pattern, and I have to chase, and that was the result of the article what published 2009, I believe. It's about the routinization of divorce practice, right? So the first timer don't get the divorce, and then they get divorce granted the second or the third time or later applications, right? So that's basically the start of the whole project. And then later on, Professor Ng joined me to do more research on Chinese court, and then basically focusing on the discourse in Chinese courtroom, right? So and then together we found a lot of things that the practice has actually led to the inequalities between the two genders. We published an article on a pragmatic discourse, right? So and then basically we argue that those discourse has a consequence of gender inequalities. We also published an article on the erasure of domestic violence, right? So because the settlement in divorce cases actually make any discussion of the domestic violence disappeared or vanished, right? So that's the second thing for the gender inequality. And then later on, I have a students like I mean in doing divorce law, and then she thinks that the inequality issue actually might lie in the different areas of the divorce petitions, not just on whether to grant a divorce or not just on the issue of domestic violence. It may be other aspects, but we simply need to explore that. So basically, from that, I think that might be a possibility to combine the routinized practice of the divorce practice and gender inequality, and then do something more systematically, right? So that's I have the from there I have the book manuscript, right? So then I explored different areas, right? So not just domestic violence and the routinization. I also get into the area of property division, child custody, and also the sexual harms suffered by women in this whole process. And then once I sent a book to my co-authors, and especially Professor Yang Su, and then he said, okay, now we have a very traditional type or stereotype of book project, right? So you have some major argument, and then you got into different areas and then different chapters to explore the different components. All right, that's fine, but it's a little bit boring. So then he encouraged me to think more theoretically, right? So is it possible to combine the argument in different areas, right? So you use the different area of legal issues, right? Child custody, property division and domestic violence, right, to support your main argument. But is it also possible to combine those areas together with the theoretical arguments such as the difficulty in implementing the law and also the economic capacity of the different parties, right? So that's basically about the property division and also about the cultural bias, and that you could use sexual harms to use to address that point. So you could have a parallel argument, he suggested, right? So I think that's what I did afterwards, right? So the other colleagues also contribute a lot in this process, right? So the Professor Chen at Department of Sociology of Hong Kong U asked me, originally I said, I want to highlight the point of institutional constraints that the Chinese judges are subjected, and then think that's the major critical role in this process. And then she suggests, okay, you don't have to go that far. You can simply say those institutional constraints indeed are combined together with other elements, other factors, and introducing such a gendered outcome. And so that's basically, it's not all the list yet. So, but actually, what I want to say here is that it is the work of so many colleagues, and then everybody contribute a lot in this process. I'm somehow just an awkward secretary in recording all of this. And again, thank my colleagues from Hong Kong U, and especially Dean Harding for organizing this. And then so also the colleagues and Ben, and also the colleagues in North America for reading the book and participating in this event. Thank you so much.
Thank you. So let me invite Siddharth to make his remark.
Thank you so much, Hualing, and it's such a great pleasure and honor to be here on this panel to comment on this wonderful book that Professor He Xin wrote. As Xin just explained, I mean, this is a book of the final product of a research enterprise for over a decade. I think as I'm a sociologist of law, so my comments are mostly talking about the contributions of the book from two aspects, the contributions to social legal studies, but also the contributions to the studies of Chinese law. I think, 20 years ago, when most of us, I think here were graduate students or young researchers, probably except for Professor Fu on this panel, that at that time, I think the study of Chinese law and the Chinese legal system were mostly doctrinal. And empirical study were actually very few, especially on Chinese course. I think when I was a kind of an undergrad student at Beida, like when He Xin was probably a graduate student at Stanford at that time, there were very few empirical study about Chinese course, and He Xin was, of course, was one of the pioneering scholars, if not the pioneering scholar, to actually engage in empirical study of Chinese course over now probably almost 15, 20 years. Right. So, so I want to say two things about the book's contribution to social legal studies, also in light of Professor He Xin's earlier work. The first thing I think is very important is that I think this book goes beyond kind of what we usually do as social legal scholars. Because I mean, for example, I mentioned He Xin studied Chinese courts for many years. I myself studied Chinese lawyers, the legal profession, for many years. So if you think about the broader law and society or social legal scholarship, and the vast majority of study actually focus on either courts or the legal profession or the criminal justice system, mostly these kind of institutions within the legal system, without actually going into substantive areas of law, things like family law, divorce, or criminal law, or civil law, contract law. I mean, there are studies in those aspects, but that's, was not the main focus, I think, for social legal studies. I think that's a strength, but also, I think, a weakness. And it's a strength because it allows social legal researchers to do a lot of studies that ordinary kind of the traditional legal scholar won't do. For example, study how courts operates. For example, how courts are embedded in the other institutional elements in the Chinese society and the political system, like Professor like Kuai and Xin did in their book Embedded Court earlier, right? But I think this book, Divorce in China, actually goes beyond that approach of focusing on a specific legal institution, no matter it's the court or the legal profession or the police or the criminal justice system, actually going into a substantive area of law, which is divorce. And then if you read the book, I think even for scholars of family law or scholars interested primarily in the marriage and divorce in China, rather than kind of courts as an institution, they would actually find the book really fascinating. So I think that's really, for in recent years, I've been actually advocating for more studies kind of going into substantive areas of law. I think that's really gonna put social legal study to a higher level than what has already been done, study Chinese law and society. So that's the first thing. But the second point, I think the contribution to social legal studies is even more important, because I think when I was reading the book, one argument I think is probably the most important argument in the book that really struck me as something quite different from the kind of the mainstream approach to study divorce or maybe gender inequality more generally, not just in China, I think also internationally, which is because, especially I'm based in North America. I mean, especially if you look at the US scholarship in law and society regarding divorce or regarding gender inequality, they always kind of have this orientation of put inequality as the explanatory element, or the so-called independent variable. So especially now, I mean, given the environment, like gender inequality, racial inequality were really probably the most central concerns for not just sociology or law, but probably across the entire spectrum of social science in the U.S. So there's this general tendency to let me simplify the approach. I mean, it almost sometimes feel like everything starts from inequality, and inequality explains everything, right? But I think so a lot of people study marriage and divorce in China or in other places also take that approach, which is a totally legitimate approach, obviously. Basically, to start from the assumption that there are broader gender inequalities in society, and patriarchy and all these kind of gender discrimination, all these things, and these things are projected into the legal system, including the court, and that explains why women face more barriers, for example, in litigation, and women often have kind of unfavorable outcomes in the divorce cases and other kind of legal disputes. And you see many kind of scholarship making that line of argument. But I think what Professor He Xin has done in this book, it's not like say that argument is wrong, but it's actually showing something very, very important and different, which is, if you go to Chinese court and actually observe how Chinese judges adjudicate and mediate these divorce cases, like He Xin and Kuai did in their decade-long scholarship, then you realize that a lot of the outcomes, the so-called gendered outcomes that Xin just talked about, has nothing to do with gender. It has nothing to do with kind of the patriarchy, all these things. Has actually more to do with the institutional constraints of the court itself, of the judges itself. In other words, when Chinese judges were making judicial decisions, what they are concerned about are actually not gender inequality. Although, of course, you can argue their gendered ideas, gender ideology, all these kind of things influence their behavior. That's, consciously or unconsciously, that's probably true. But at the same time, a lot of things they were thinking about when they're facing a divorce couple, a couple seeking divorce, is really things like efficiency, things like assessments, how they will be assessed by the judicial system, by the kind of cadre evaluation system of the court, and how they're constrained by all kinds of resources, and how they're constrained by the certain kind of, what Xin called pragmatic discourse in court. And all of these things have nothing to do with gender. You can use the same framework about institutional constraints to analyze divorce cases, but also to analyze other kind of judicial decision making. So I think that's really an important contribution of the book. I think, so it is about divorce, but it's also the contribution goes beyond divorce. It shows this more general logic about how Chinese judges think. Like there is a famous book, of course, by Richard Posner, How Judges Think, right? And this is really how Chinese judges think, I think, to a large extent. And also it shows the importance of taking these institutional elements into consideration when we think about issues of inequality, no matter you're talking about gender, race, or class, or immigration status, or other things. So I think that's really, to me, the most central and most important contribution of this book to social legal scholarship. And then I want to quickly mention another important contribution of the book to the study of Chinese law, and then I'll stop. For many of us on this panel, and also probably in the audience, we probably well aware of the fact that the rise of what Professor Fu Haling just mentioned, like the law and social science in China, 社科法学, the so-called empirical legal studies or law and social science in China, is, we always think that the rise of law and social sciences is the opposite of the so-called doctrinal legal studies, the 教义法学 or 法教育学 or 规范法学, right? So 社科法学 is the opposite of 规范法学. But I think in recent years, I see this very worrying trend in the law and social sciences in China, which is the rise of the so-called big data, or the so-called 数据法学, the data. I don't even know how to translate 数据法学, data legal studies, maybe. It's not even empirical legal studies, because what they mean by 数据法学 is more about using big data, especially the fact that now there are millions of judicial decisions published, right, by the Supreme People's Court. They're available out there. Anybody can collect them and analyze them, right? So I think what happened in the past 5 years or even more is that more and more legal scholars in China, but also internationally, started to use these kind of big data to do empirical studies on Chinese law. And there's a whole industry doing that right now. I'm personally actually very skeptical about this effort, because not because I don't do quantitative analysis, I don't like quantitative analysis. That's my own bias. But I think the problem with the so-called 数据法学 is that the focus on the judicial decision itself is actually disguised 90% of what's actually going on in the judicial process, that leads to the actual judicial decision. Because what's written in the judicial decision is actually a very small percentage of what's actually happened, as this book, Divorce in China, very convincingly shows. Because when these Chinese judges are making decisions in divorce and in many other kind of civil cases, I mean, first of all, a big percentage of cases do not even reach a judicial decision. They're mediated, right? And if you, even for those cases, actually reach a decision, what you can observe in the judicial decision itself, and what you can observe in a trial, how the judges actually talk to the litigants, talk to their lawyers, as Chen showed in this book, are quite different, are very, very different. So to really understand China's judicial process more generally, and especially in divorce case, I think we really need to go beyond this kind of blind belief that these kind of judicial decisions, millions of judicial decisions, actually going to show the big picture of what's actually going on in Chinese courts. So I think Professor He Xin's book actually it's an exemplary study of how to actually do not use that kind of 数据法学 big data approach to actually go deep into the court, do ethnographic work, do interviews, and present not just a more nuanced and more complex picture, but actually a deeper, much deeper picture of what's actually going on in the judicial decision process, what the Chinese judges are actually thinking, and how they're actually deliberating, and what are some concerns, some factors that they take into account when they make decisions. So I think that this kind of study is really, I think, 100 times more valuable than the analysis of a million judicial decisions published out there. So I think that's, I think, the most important of the contribution of the book to the study of Chinese law. I'll stop here. Thank you very much.
Thank you so much, Sudha. It's quite raised lots of questions, and I think will be some of the issues will be matters to be for the discussion. I think the 数据法学, I don't know whether it can be translated into like a digital legal study or computational legal studies, which we've been talking about. But in any event, so I think the next commentator is Ben. The floor is yours.
Hi. So thank you very much. It's a privilege to be able to read this book and comment on it with a panel of such distinguished professors. I'm very glad I'm following Professor Liu actually, because many of my comments flow from his. So the first thing I'll say is this is a very remarkable contribution to social legal studies. There's no doubt about that in terms of the institutional detail, the amount of fieldwork that's gone into it. It truly continues this tradition of looking beyond what the law is on the books to what the law is in action. And superficially, it looks like this is a book that reprises a theme of the haves coming out ahead. So superficially, it looks like it's another book on why people with better resources succeed in courts that are neutral. Even when the law applies equally to all, some people have better resources, they have better access to lawyers. If they're repeat players, they can game the system in a way such that they can kind of forgo individual victories to serve a larger picture, a larger goal. But this is not just such a book. So the key thing about this book, as Professor Liu mentioned, actually, that also struck me is his contribution to judicial decision making. And that's where I'm going to focus on. I'm going to talk about how this book, to my mind, is also a very important contribution to the field of judicial decision making. So I'll start maybe by presenting the standard picture that all graduate students learn about judicial decision making if they're trained in the US. And the standard picture is that there are three models. The first model is the legal model. Judges follow the law, and that very soon was criticized, and there was the rise of the attitudinal model, which suggests that judges decide cases based on their ideological predilections, based on their policy preferences. And finally, that too was kind of, in a sense, swept aside by the strategic model, which is that judges do maximize something, and it could be policy preferences, but they maximize it in a way that's strategic. They take into account the kind of responses of other actors, and so they don't always vote what they think is right or what they want. They vote taking into account what other people might do in response to their decisions. And this is a very US-centric model, but it's a model that has been applied to other countries. So for example, to the case of Egypt, how their kind of Supreme Constitutional Court navigated the political dangers of ruling against the government in an authoritarian state. It's also applied to the case of the Russian Constitutional Court by Epstein, Knight, and Sova, about also the dangers of poking, a very powerful executive. But where Professor Hershin's book is remarkable, I think, is the change in focus, is a shift away from looking at appellate constitutional courts to trial courts. And this is what truly surprised me. And I think it's only possible because of the amount of field work and the amount of effort that's gone into data collection. Let me say a little why the literature has neglected trial courts. The literature has very much neglected trial courts. First, because a lot of this comes out of common law jurisdictions, right? And so in appellate courts, the decisions have precedential value. And when you get to constitutional courts, the decisions really touch on the fundamental rules of the game. So not just, very small decisions involving individual litigants, but, decisions that affect how society, how government is structured. And so it's thought that they are of greater public significance. A lot of attention has been paid to appellate decision making, judicial decision making, because it seems important as opposed to trial court judicial decision making, which is very retail. But this book really changed the way I look at it. When I read this book, it struck me that actually trial court judicial decision making can be very important for understanding the law, how it's implemented, and how it evolves. And I think what Professor Hershin has very successfully managed to do in this book is to show how the system creates uniform pressures for judges, right? And they face a kind of common incentive, and so they act in a certain way, even though they are not coordinated, even though their decisions individually have no precedential value. But the system operates in such a way that they face the same incentives, they act the same way, and all of a sudden, trial court judicial decision making actually, to my mind now, doesn't seem any less important than judicial decision making at appellate levels. So let me maybe give a summary of the arguments in the book that kind of support this view, and maybe for the audience who haven't read the book, this can give you a teaser of the book and why you should buy it. And so essentially, the book kind of argues that the legal standards articulated in Article 32 of the marriage law are quite irrelevant, actually, when it comes to divorce litigation. What's really driving the kind of patterns we observe in the data when it comes to divorce litigation are the trial court's obsession with efficiency and stability. Now, on the one hand, they want to close cases as quickly as possible. On the other hand, they want to close it in a way such that they don't create trouble down the line. Right? They don't want a case where a disappointed litigant takes extreme measures that might threaten or undermine social harmony. And so the strategy has developed. What trial judges do in such a scenario is they basically deny the first petition for divorce. And the reason for that is, it reduces their workload because they kind of sidestep very tricky questions of division of property and custody, increases the closure rate. It looks like cases are being closed at a much faster rate. That helps the metrics. And finally, there's the low probability of appeal. And this is very interesting. There's a low probability of appeal because the losing party, in a sense, right, the party that didn't get the divorce, knows they can get it in the end. They just have to come back at a later date, right? So they're not losing, once and for all, right? In the sense that the difference is being split. And if they were to appeal, apparently, a remand will take more than 6 months. And so it's much better for them to just come back in 6 months and get their divorce. And when it comes to the second petition, usually, it would be granted unless there's certain outstanding or exceptional situations. But usually it'll be granted because by that time, the parties have kind of accustomed themselves, kind of familiarized themselves. They are now kind of more adjusted to the fact that divorce is going to happen, right? And so their decision will be rendered. And so this is what's so great about this book. It shows you this kind of systematic gender bias that's produced, not because the court is itself biased, but because of systemic pressures, right? And these systemic pressures at the lower courts, in effect, create a kind of effect that is no less significant than appellate decisions. This is what I find fascinating. So kind of moving on to the broader picture, I think this book raises a lot of questions, both from the social legal perspective and from the perspective of judicial decision making. I won't reprise. I won't repeat the interesting questions it raises in social legal theory. One of them, which is the perennial one, is whether state ways can change folk ways. But the other very interesting question this book raises is, what do judges maximize? Because this question has been well answered when it comes to appellate judges, when it comes to judges in common law jurisdictions. They maximize their policy preferences. Many of them are in judicial office because of the esteem, the prestige, the reputation that comes with it. And so they also try to avoid reversals that are embarrassing. They try to be friends with their colleagues. But the same question hasn't really been asked of trial court judges or judges in civil law-based jurisdictions. And I want to quote this a line from the first chapter. It begins with this quote. It's said to be a common saying. Paid as land use farmers, we shoulder the liability of heroin trafficking. And I think it raises a very interesting question of why do legal professionals in China choose to become judges, right? So what are they after? So we see them responding to these institutional pressures, right? But what are their goals? What are their hopes? Why do they become judges instead of pursuing a more lucrative path maybe in private practice? And I think the answer to this question will kind of help us move forward, right, in terms of policy and in terms of institutional reform. Okay, so those are the extent of my remarks, but I want to also briefly to offer a response to Professor Liu's very last comment about big data. And I really do want to also caution against this frenzy about using big data. And I would say ultimately the question is, what are you trying to achieve, right? What is your research goal? What is the research question? And once you figure that out, then it makes a lot more sense, whether or not big data is the way to go or fieldwork is the way to go. For Professor Hershing's book, I think this was very, very successful. Just in terms of the true insight it gives into judicial decision making, right? So in terms of cases, the opinions don't really go to the heart many times of the issues being litigated. And so when you look at these databases, your research question must be focusing, I feel, on a very limited number of things, right? So maybe first it's the case disposition that matters, right? If all that matters is the case disposition, what was the final outcome? Then maybe you could use big data, but you have to take into account, of course, the selection bias. What you get at the end is only a subset of what was litigated at the beginning. In some cases are not litigated. Or the second reason for using big data and looking at opinions is you're interested in the language itself, right? So you're really interested in how things are being talked about in opinions. In which case, use of big data will also be very useful. But for the kind of project that Professor Hersin has in mind, and I think it's usually a more exciting kind of project. This kind of fieldwork is really invaluable, and I'm really glad to have an opportunity to read and to learn from this book.
Thank you, Ben. Let's move to Professor Ng for your comments.
Sure. I think Sita and Ben, they cover a lot about the book already. I don't know if I have much to add to their wonderful comments. But I would just proceed with some of the points that I've prepared. I was asked to perhaps situate the book in the broader scholarship of Chen. And because I worked with him for many years, and so I have insider knowledge about his scholarship, and I do, and so I'll be happy to say something on that. Obviously, this is not any last work on the merit of his scholarship or whatnot, but I'll be happy to throw a few points. The first point I want to make is I really see Hersin as an institutionalist, and I think that's the point Sita and Chen himself would actually agree. If you compare his scholarship, I mean the approach in the book, how he analyzed divorce in China with other very compelling accounts about the gendered outcome in judicial evidence. That stand out, I would say, is the emphasis on cultural factors. By cultural factors, I mean things such as like patriarchal order or some of the traditional norms. I mean, he did mention that a little bit. He has a certain thin theory of like culture, I would say, particularly towards the end of the book when he talked about cultural biases, which is a way to talk about some sexual taboos in the court, like male impotence. The court kind of like shy away from that, but when it comes to like female infertility, then the court had a different attitude. So that's that element of it. But by and large, when it comes to analyzing the causes of gendered outcome in these cases, he emphasized a lot more about the institutional constraints, and it is very obvious in the first 3 chapters of the book. And I think, it's been pretty consistent in his work that institutional constraints trump a lot of other cultural or even social factors. What kind of institutional constraints we're talking about? Ben and Sita already mentioned. Basically, the courts can never shed its skin as a grassroots bureaucracy. And so they are obsessed with maintaining stability. They are also very much concerned about their efficiency, their output. In the book, Hersin mentioned about the performance system that are used to judge all the performances of grassroots judges, and they are subject to tremendous, immense pressure to deliver, to resolve cases, not to delay any cases that they cannot be closed, and things like that. And under such pressure, they got to find a quick way to resolve all the problems. And because of that, they cannot spend too much time investigating, sorting out things, and they want a quick resolution. And when convenience and efficiency is your primary objective, what happens is that a lot of like gender inequality matters kind of like swept under the rug, or just put aside. And it is not so much because judges actually share, well, some do, I believe, but not all of them share all the kind of like patriarchal norms and values. If that's the case, then you would expect younger judges, female judges, perhaps being more sympathetic to women plaintiffs. But that's not the case. In fact, for many of us who study the courts in China, we find out that younger judges oftentimes are less sympathetic about a woman coming from the countryside, suku, uh, speaking bitterness to the court. They don't have that kind of like patience, and they don't think the plaintiff actually present a convincing case or credible case in that case. And so what they do is, well, they rule according to the law, and they think, it's safe, or they try to mediate and try to talk the woman into accepting certain kind of like compromised or negotiated outcome. So that's number one. I think, that approach to see the court as a bureaucracy, I mean, the institutional approach, really stands out, and it has been a constant theme in his scholarship. And the second is, I think this is really one of the distinction of his like approach, which add a lot of like granularity to his analysis, and that's his focus on like discourse. We wrote a paper together called Pragmatic Discourse back 6 or 7 years ago. I lost track. And Chen has been producing so many more articles since then. But he really wanted to see how judges deploy different types of like discourse. And Hersin understand the term social discourse in a very kind of like innovative way. Discourses are deployed to speak to people, different groups of people to achieve strategic goal. And so being a judge in China, you cannot just speak the legal discourse. One would have thought, if you're a judge, you talk about law, law talk, and that's all that is. But that's not the case in China. You got to have like different modality of like discourse. You have to engage in legal discourse sometimes to show that you know the law. But perhaps sometimes more important, you have to be able to engage in this kind of like pragmatic discourse, to talk to different parties and to persuade them that this is the best outcome for your own sake. And one of the more recent article, and also in the book, he talks about the mediatory discourse, using the distinction developed by Sarah Engelmary about the legal discourse and the mediatory discourse, and he classified the pragmatic discourse as a form of a mediatory discourse. And I think the reason why he focused so much on discourse is that he has that wonderful access to a lot of like court data, court trials. He was like the fly on the wall, knowing, hearing all the conversations between judges and litigants, and he could come up with a certain analytical framework by invoking the concept of discourse to analyze his rich empirical data. And I think it is an aspect of a scholarship that contribute to the kind of like power and persuasiveness in his analysis. The third thing I want to say is I'm still debating with myself how should I name it. I would just call it tentatively holistic judging. So we wrote a book together. We call it Embedded Courts, and the embedded courts is about the court being not just using the law, is actually embedded in some other social institutions, social embeddedness, cultural embeddedness, political embeddedness, and economic embeddedness. And what we are trying to talk about is the court actually do not just use the law. Now, I think one way to read the book is that if we apply this kind of like embedded framework to understand how the court rule, what kind of like judging comes out from it, then we would see what happened in all these divorce cases. What happened is a form of like holistic judging. By that, I mean, there are many separate and supposedly independent components of a simple divorce case. A woman may want a divorce, that's true. And then a woman may also want custody of the child. And a woman may also want to divide up the marital property. What happened with holistic judging is that all these different components are all linked up together and ruled as a whole. So if you want a divorce, well, you have to give up your son, give your son to the husband, and I'll grant you the divorce. If you want a divorce, I may not be able to divide your property 50-50. You may just get 30%. And it's pragmatic, it's bargaining, it's also what I would call holistic. And if you think about it, it makes sense because the court does not just consider the law. We like to think about, the law and society paradigm as like exploring the gap between law on the books and the law in practice. And sometimes I think when you study the court in China, to talk about the gap is still not enough. Because when you talk about the gap, you're still using law in the books as a baseline for you to compare, as how far the actual practice deviates from the law. But that's really not the way sometimes happening in the courts, because judges use the law very innovatively. So you use the law in a very strategic way. And what happened is that they just focus, set their sight on the outcome. And that's what I want to capture with the idea of holistic judging. And I would want to think that this is perhaps one way to flesh out more about the embedded thesis that we first put out. But of course, the book in and of itself is a lot more. I guess I'll stop there.
Thank you. Thank you so much. I think to the audience, if you have any question to ask Professor Hexin or any panelists, just use the Q&A function to ask your question. So before we open up the floor for discussion, I would give a few minutes to Chen, whether you have any immediate pushbacks or comments.
Thank you for all this kind word. I think they're being so polite, and they only emphasize one aspect of the book. So there's not much that I could say. I think I agree with most of them. accept the point that like Sida of course has the same tendency like mine, and quite like we prefer to do qualitative work than quantitative work. So, but we may not want to say that the 数据法学 or the data research is a dead end, right? So there's still something out there, right? So just depending what's, like Ben said, or what you are looking for, and they can still come up with some part of the puzzle, right? So the decision, you can see the general pattern, and then once you have the general pattern, and then you can dig out reasons behind. So so for my own I mean, for this for my own book, I was still encouraged by the quantitative work like done by Michelson, right? So that if because what I do the field work, I do interviews, and then I find a pattern. I think I find a pattern, but I don't know if that's true, right? So then once Ethan Michelson have the data, and then they have the outcome to show that in many ways that actually this is true, right? So then it's just offer me well, it's such a relief, like I mean, so because it's once you do these things, you're not that confident, you know, whether you're actually right? So, but if once the data and Quai also done some similar quantitative analysis based on the Beijing data as well. So then and those things I think will help complete the picture, right? So. And on the point that Quai raised that an institutionalist, I agree. Like I mean, so even in our co-author book, Embedded Course, there's no such thing called cultural embeddedness, right? It's only political, administrative, economic, and social, right? So social, of course, has some link with the cultural embeddedness, but it's not really that kind of thick and dominant theme, right? So in explaining judges' behavior, but I do agree. Like I mean, in this topic, when I do the research, I find that institutional impact is the dominant, far more impactful than the cultural explanation, right? So you could simply change the different generation of the judge and different gender of the judge, right? So Eddie Wei, like I mean, is a student at Cambridge and did a research between different genders of the judges on making those decisions. They find basically there's no difference between the male and female, right? So and in a way, once we are subject to this kind of institutional constraints and assessment criterion, we have to respond, right? So my dean asked me to do a lot of research, so that here I am, right? So that's the kind of institutional constraints like we have to face. Other than that, I think I just have to say thank you so much.
Thank you. Thank you. I think, okay, let me just start the conversation, right? I think I have two, I'm not sure it's two questions or one question, right? So your scholarship, I mean, the intellectual framework is from social legal study, right? It's very sort of North American, right? It needs the key researchers start there. And then you use the framework to look at Chinese courts. So when I read this book and the other works of yours, So somehow I was asked a question is, how, okay, that's how things are done in Chinese courts, those are constraints. But then we're talking about the families, husband, wife, mother, child. So you have the same constraints in, say, let's say in a small city, in a small county in California. So I guess the question is by now, I mean, after 30, 40 years of legal reform, how different it is in terms of court making decisions in a family court. Is Chinese judging fundamentally different from, say, in family law, divorce, custody, partition of property, different from, say, how things are done in a city court in California? I thought those kind of socioeconomic constraints, right, are quite common. Right? The relation is more. So what I'm trying to say is, it is about husband and the wife more than, say, Communist Party and the family or the individuals. So do you see that trend? I mean, moving along at a certain stage, you would say the Chinese judging in family law is more like American judging than the Chinese own past. Things have shifted so much. So that is one part of the question. The second part of the question is, look at China, right? There is the political logic, right? Quan used the term institutionalist, right? I think I used the term political logic. So the party insists on stability. You must do things. You design quotas, index, key indicators to force judges into certain mood of thinking, right? That has been the case. Nothing has changed, right? I think Deng Xiaoping talked about stability, overriding everything else. We're still talking about the same political language. But then the judges should have changed. We have lawyers, we have almost 500,000 lawyers now. We have so many judges, they're all well-trained. Doesn't make any difference. Or still, once they are judged, they will just change everything, follow this simple institutional political logic. Or alternatively, what it takes to have a sort of paradigm shift, to take them more seriously, whether they have something that is normative, right? I suppose we're supposed to be better. We're supposed to be, fair, right? Yes, there is the political constraints, but then they change it. So that is some of the larger question, say, to whether it could kickstart a conversation. Anyone to, I will probably just start with Sida. Any immediate response, or and then have a round of conversation on that.
I mean, first of all, I want to quickly echo what He-Xin said earlier about the 数据法学. I want to clarify what I said earlier. What I meant was not like, oh, quantitative analysis was useless, but what I was, let me make an analogy, which is like, I think for many years, like those of us who do social legal studies on Chinese law always complain, 无米下锅, there's no rice to cook because there's no data. We have to kind of, do interviews. I mean, there's really no numbers, no statistics reliable statistics to use. And then of course, all of a sudden there's this kind of millions of judicial decisions, online, right? So now there's rice to cook, right? But I think the problem is that I think the worrying trend I was talking about earlier was that I think a lot of legal scholars these days, they think cooking plain rice is enough to make a dish. Basically, you just rely solely on these judicial decisions. You can do excellent kind of big data studies. I think what He-Xin said earlier was actually really important. I think these things are complementary. You gotta, complement the, like the numbers with interviews, ethnography, and vice versa. I think these things, and then we can achieve a much better understanding of a phenomenon. Like I think the Ethan Michelson study, like it's a quantitative study using big data, showing the macro patterns of divorce outcomes, gendered outcomes in divorce cases. It's actually really complementary to what this book showed, which is like actually quite. I mean, if you combine these studies together, you got a really comprehensive study understanding of divorce. So I think that's really important. So in other words, to make a good dish, you not only need plain rice, you also need vegetables, meat, other kind of ingredients. And that's, I think, sometimes more difficult to obtain and sometimes take more effort and is kind of a worthwhile effort to obtain, as Hexin did in this book. And also regarding the political logic, I think Professor Fu just mentioned, I think divorce is actually a good case to think about this, because I mean, some of us, like including both myself and Professor Fu Haling, study criminal justice, right? Like how criminal justice system work, criminal cases, criminal procedure work in China. And by definition, those are very political areas. You see the political logic, right, at work. So sometimes I think there is, I think, this argument, I think, that China is building a kind of a dual state model or a dual track model of the legal system, where for the more political or more sensitive areas, there's a set of rules and set of party influence and political logic, and then for the more ordinary cases, like say divorce or civil cases more generally, say intellectual property, patent, contracts, other kind of non-political or less political cases, there will be a different logic. But I never really find that argument convincing, and I think because I think there are more general institutional arrangements. I wouldn't call them institutional constraints, because I don't think they're not. I don't think they're just constrained. They're constraining judges, but they're also enabling judges to do certain things, under the institutional arrangements. So I think that what this book, Hexin showed in this book, is that even in the most mundane divorce cases, you still see those, institutional or political logics at work, right? So I think that's actually a very powerful piece of evidence to show that these things actually go beyond certain kind of political or sensitive areas of Chinese law. So that's what I want to kind of, offer on the table.
Thank you. Other comments?
Well, I can briefly respond to the difference between what I said about institutionalist factors, features, or constraints. That was the word I used, and political logic. I think political logic is some kind of like goal, or some kind of like overarching objectives, like stability. I mean, everyone studying China know stability is the primary objective, is like really important to the party state. But institutionalist constraint, I think it is more about what kind of like practice, know-hows, features can put into the court to make sure that maintaining social stability is achieved. What the work done by the court facilitates, not undermining, but not undermines stability. And that is actually a more complicated problem than many of us would think. China is a big country, is a populous country with a lot of regional differences. And I think one of the primary concern for the central government, and that concern manifests itself more prominently in the past few years, is how can I make sure that the law I passed at the level of the SPC, or certain guidance I issue at the SPC could be honored, in a remote dispatch tribunal in an inland province. And if it's not honored, is it not honored in a way that I agree it is conducive to the maintaining of a social stability? So, I mean, those are the things that people at the top has to struggle with, has to think about ways to make sure that is happening. And we see things like they they impose judicial reform. They bring in the whole idea of like lifelong responsibility. They also raise the salary of our judges, and those are, you know, kind of like multiple ways to make sure that the political logic, or, you know, and objectives behind the political logic can be what the court is trying to do, what all the grassroots courts are trying to do, can actually promote, you know, those objectives. So that's one thing I want to respond. The second thing I want to say very quickly, and I don't want to dominate the entire discussion, is Professor Fu, you mentioned about, you know, judges nowadays, do they see themselves as different, and, you know, they're dealing with like lawyers now. I don't know. I think that's a question that many of us want to know the answer. I think we are seeing some change, but would that get up to the point where you can become an inflection point? I'm not sure. By that I mean, yeah, there are more lawyers, but when you talk about divorce cases, I think in more cases than not, we are talking about unrepresented litigants. And when lawyers actually appear, they do not actually argue legal points with the judges too much, but, you know, they are thinking about how we can get more from the other party, just to make sure that, you know, there's no money hidden by the other party and things like that. And the other thing is, if the analysis of institutional constraints, embedded nature of the court remains unchanged, then I don't see a very pronounced rise in the identity of being a judge, which is a professional identity. I'm not saying that that won't happen, but I think right now, I think it's still fair to say that many judges, including the younger one, understand first as a grassroots, second as a judge. Now, of course, that requires a lot of like qualification. If you're working in the IP division of a certain Shanghai court, that may change, but I'm making a very general statement here.
Right. Thank you.
Can I just add a few point? I don't want to pretend to be expert. Sida is here, so when it comes to the lawyers, the dynamic in divorce case, one thing is that maybe overall, there's the percentage of cases represented by the lawyers is still very low, and in many ways, the more important thing is that in many ways, the lawyers try to screen the litigants, try to repress the claims of the litigants instead of fighting for them. It's the opposite. So Liker's study, like I mean, on the rural areas, basically shows that how those lawyers, or the not really lawyers, it's the legal workers. The legal workers actually repress those claims and say, hey, you can't get custody, and you suffered from domestic rape, and that's what he did was lawful, right? So it's this kind of thing. It's not really try to, I mean, what the lawyers did is actually a reflection of what judge is going to do. And then those lawyers, and especially the legal workers, relied upon the court and the judge to make a living. So they do not really try to rock the boat. They try to help the judge to mediate the cases. They are the forces actually blocking the so-called normative values to be implemented, and then the development of a more equal society. Right? So and as to the institutional, the argument of the institutional argument, if you compare different era of the China, and then also compare China with California, then I think the answer is quite straightforward, right? So California judges will not decide cases based on what Kwai suggests as a holistic way, right? So custody is custody, divorce is divorce, right? So you can't put divorce in together with custody and property, right? So you have to make some choices out of it, right? So and then if you compare what we had in the 1980s in China and what happened afterwards, and you see the huge difference, right? So because the political goal may be different and institutional incentives might be different too, right? So then back then in the 80s, perhaps it's very difficult to get divorced, but nowadays it is possible. But it follows a different pattern and different incentives.
Thank you. Ben, you have anything to comment on?
Yeah, no, so I was thinking about the suggestion that Chinese courts might be moving closer to American courts in this area. It doesn't seem like it, right? I mean, I'm not an expert in this particular area of the law, but just reading the book, it seems like what has changed in China at least is the discourse, right? So they're giving up the idea that the purpose of socialist courts is in a sense to educate and in a sense to reform, right? I mean. Back in the Soviet Union, even then, courts had a lot of latitude to deal with criminal cases. And the reason why they had that latitude was because the point of socialist courts was not just to implement the law, but to reform someone to become a useful member of Soviet society. And so they had that latitude. And when I thought about your question, right, it seems to me that, at least as documented in the book, what has happened is courts have retained that latitude. Courts are still doing this kind of mediation. But they're no longer striving for the same goal, right? The goal is not really to reform or to kind of to educate people in the proper ways of being a socialist, a member of socialist society. The goal really has become about stability, right? And that, in a sense, I think is just so different from the legal logic in the United States. I think what seems to be similar on the surface is they're moving towards this kind of no fault divorce, right? I mean, there's no longer that moral language associated with preventing divorce, but the legal logic is still very different. So I cannot imagine in the United States any judge who engaged in the kind of pragmatic discourse that was described in Professor Hudson's book. It's just unthinkable. Of course they want the parties to settle, but they would never, I think, kind of suggest any outcome in advance of a ruling, or they wouldn't even talk to the parties one-on-one to kind of push them into a certain direction. I think that even in the state courts, that won't happen.
Thank you. All right. I think we may have some difficulties with our Q&A function today. Let me see. We got the question. Okay, it's here. Can all you read the question, He-Xin?
Yeah, I'm reading it.
Okay, I just arrived. I guess so. Yeah, I thought it remind me of my own question as well. Is I think I forget who raised the question. Is okay, divorce is unique because you can't always get divorced if you come back 6 months after, right? So there is a different dynamics. So then what about other cases? I guess the question is how unique the divorce court is from, say, labor, small claim, contract. So I guess they are all subject to the institutional constraints. So I guess the question is how different it is. So Chen, you want to have a go on this question from Eddie Wei?
Such as homicide in some cases. I believe so. I think even to your just your comment just about the labor and other type of cases. I don't think you can ignore the institutional constraints and just say we go ahead with the law, right? So the labor cases we already show, like, I mean, if there's a protest, and Professor Chen from Baptist University also showed that political consideration is a dominant one, right? So and then Kwai and I was in a panel for students' dissertation on the medical disputes, right? So and if we go into that kind of disputes, you will also see that to what extent a patient or a victim of those negligence of the hospital can respond would actually affect the decision of either the hospital as well as the court as well. So so for Eddie Wei's point, other type of related cases such as homicide and assault case, yeah, that's also true. So I happened just to co-author an article with a student. We focus on how the woman actually suffer from domestic violence and eventually kill their husband are treated. And that's very interesting case, because the general impression from the media is that the court becomes more and more lenient toward this particular group because they kill, they are murderer, but actually they suffer from domestic violence. That's the major reason, right? So we compare the decision before and after the Supreme People's Court change the guidelines and then offer a lot of legal help for those for this particular vulnerable group. But what we found actually, there's no significant difference statistically before and after the legal change. Most of them still suffered, get a lot of heavy sentences, like 10 years and up for killing their husbands, even though they were beaten to death before that. Right. So it is true, and if it applied to the other areas, it's kind of very sad, but it seems to be more applicable to those cases only limited to divorce cases.
Right. So let me just read out the question. I think there's a question that we answer the question without stating the question because the audience cannot say the question. And then the question is, Professor He's study demonstrated that female litigants' interests sort of inevitably sidelined. So if that's the case, so what's the implications of his study on gender bias in Chinese court law? So I think Professor He just gave the answer to it. Mm-hmm. So as I said, the question is between the reality and the normative universe. I think he just said it's pretty sad to say it. I guess always I have this lingering question is, there are lots of people pushing for the reform, right? Domestic violence, gender equality, and the only revenue is the court. I mean, so what would be the answer? You have attended quite a few workshops for lawyers and NGO, right? So how do you answer their questions, right? We've been trying so hard. That means that your answer is what, regardless of what you try, then there's the institutional constraints. So where do solutions lie then?
Right. So that's yeah. I do respond to those concerns. I think I believe those efforts on the law side, on the lawyer side, are actually helpful, and even especially the education on the judges. Right. So the training, and it's not education, it's just the training, like to offer them this gendered perspective, and then that's really helpful. right? So if I have to if I have to compare the judges from the two court that I did interview, then you will see the huge contrast between them, right? So in the developed area, the coastal area, the judge was very professional, well-trained, very gender conscious. So she knows exactly what we want to know, right? So then she's very careful, to show that she's really neutral based on gender, but eventually you still see that the decision still, some areas still show exactly that she cannot really hide, right? So it's about the erasure of domestic violence in the settlement, it's about her pragmatic discourse, this kind of thing, right? But on the other hand, if you look at the judge in the hinterland areas, they may not even realize gender is an issue, at least at the very beginning of my research. They believe that we are following the law, and then the gender equality is great already. So they don't realize the problem. So until later, like we show that the contrast and then the impact of their decisions. So I believe that the training for the judges will be helpful. And then, of course, the most difficult part is the institutional constraint itself, and that's really hard to change. You know, the court rely on those judges as the agent of the state to implement the law. And then they must find a way to assess their performance, right? So, and then that's why they create this set of rules, right? So in the meantime, the legal reform seems to give a lot of room for the judges to make their own decision. But they still, I mean, the only thing is that the supervisors don't have to approve their decision, but they still check their appeal rate. They still is going to question or even grill them if there's a malicious instance out there, right? So it's not just the court is going to question what anything wrong with the whole process. I mean, the party disciplinary division is going to step in and then make a comprehensive investigation. If there's anything wrong on the media, right? So there's an outbreak of the media mania, like about certain issues and certain silly mistakes, typos, this kind of thing, and then the judge in serious trouble, right? So. So it seems very, at the end of the book, I mentioned that it seems very difficult to step out of this dilemma, right? So you want them to implement the law, but you also want them to do other things. And then that's why we impose these kind of institutional constraints. And then of course, under these kind of institutional constraints, certain things must be twisted, right? So then the point to say to reform is try to see how to adjust the incentive in structure and see how can we allow them to have, I mean, less care and it has a little bit more immune to those consequences of the system, right? So then they may can implement a law more gender neutral, right? So of course, those other efforts are important, but here how the judges make the decision is the center, right? So they make the final decision, and then as I just said, and then I'm sure that Sida also agree. Like I mean, so the lawyers are trying to, I mean, the majority of the lawyers, except those that hard or whatever, the rights advocating lawyers, right? So the enormous amount of lawyers try to rely upon the court and judge to make a living. They actually have to cater to the needs of the judges to see how they make the decisions and then act correspondingly. Right? So.
Thank you. We have the last question, right? I'll let you go after that question. You answered part of it. The question is, are there regional variations? So GDP, men to woman ratio, and other variations. So do you see the impact? I think you just answered part of it. Maybe I just probably invite you and others. I could ask Sida, do you see regional variation in terms of the attitude, the positioning of lawyers in courts? So I guess in ways, in the back of my mind is China is just such a big entity. There's so much regional variation in terms of performance and the capacity of lawyers, judges, and the institutions. So whether and how that is reflected in Hexin's work and the work of others, the panelists. Can we just have just a round of short answer to that question before we wrap things up? Should I just ask Sida to start on that question?
Yeah, that's a great question. I think generally speaking, I think in terms of lawyers, legal services to divorce cases, I totally agree with what Hexin just said, which is like lawyers are in a way parasites to courts, in the sense that they, I'm not using the word parasite in a kind of a negative way, but like in a neutral way. So they're basically rely on the court for so many things. So in that sense, I think the institutional logic or the institutional constraints of the court are projected into the legal profession, into legal services, where how lawyer provide services. So I don't think there's so much regional variation in terms of that. But I do want to emphasize one thing very quickly, which is, I mean, Hexin mentioned there are activist lawyers. I mean, like Professor Hu Hualing, did some, really of the best work on activist lawyers in China. But there are also activist feminist lawyers. I think they're a different group from the activist lawyers doing human rights cases or other cases. And I think they are actually becoming increasingly important. And there's a huge regional variation in terms of that. I think a lot of them are actually in Guangdong, in Guangzhou, and like in this area, and much less so in some other areas. So these feminist activist lawyers, I think, are doing some of the very interesting work in terms of how to fight against domestic violence, how to even hold some courts or judges accountable through the media, even through performance arts, together with feminist activists on the street. I think that's something I think worth keeping in mind. I'll just say this.
Thank you. Ben?
Yeah, thank you so much. This is always a question that comes up when you present qualitative work that looks at two courts, and people ask how representative it is and how much variation there is. And I'll make 2 points, one serious and one joking. The joking point is, if I could survey all courts in China, I won't be an academic anymore. I think my powers would have far transcended those of an ordinary academic. But the more serious point is, what in theory would we expect to change, right? So in terms of, Professor Hexin's work, in terms of institutional constraints, maybe different court presidents will take a different view. They will weight maybe the metrics a little differently, but I think the ultimate logic is going to be the same. I think what's interesting is how does the variation in the population, right, in terms of their education, their financial resources, change the outcome given this institutional constraints? Because what I learned from this book, right, is that, to some extent, it is judges reproducing gendered discourse to some extent. But a big part of the book is that judges are not consciously trying to apply the law in a gender biased way, right? They're being subject to certain kinds of constraints, and the effect of those constraints, by and large, is to lead to this kind of gendered result, right? And so I think the interesting question is, how does the different position of the litigants in different parts of China, right, cause different outcomes given the same constraints? Because I think the constraints everywhere are the same, as far as I know. All courts are worried about efficiency because these numbers go up eventually to the Supreme People's Court, right? And they're all concerned about not, giving rise to mass incidents or malicious incidents. So I think, if we ask the question from the other direction, not so much whether or not the institutional constraints change, but how the positions of the parties change, for example, between cities and rural areas, then I think we have a better sense of, in which direction we expect the outcomes to be patterned. Okay.
Thank you. Professor Ng, you have anything to add?
Sure. I'm going to be shamelessly ask you to go back to my book. And I can say that because it's also a book written by Hassin. In the embedded courts, we deal with regional variations by invoking two ideal types, the work unit courts and the firm courts. And we suggest that, the kind of like pressure they are facing, the kind of like supervision they are facing are different. Now, of course, China is too complex to be like neatly divided up into a dichotomy. But we developed that kind of like framework to understand that different courts are facing different constraints, and not all judges are like dealing with the same kind of like institutional constraints. So I recommend, perhaps if you have time, going back to the passages in that book. Thank you.
Thank you. Chen, you have the final word.
Right. So before I say more about facts, I think I just respond to the point of regional variation. So the last point about the feminist lawyers, I think it's a very great point, and I really like your article, right? So about what's the title? Active performanist or something like that.
Performing activism.
Or performing activism. Okay, anyway. So, but what you show actually is the crackdown afterwards, right? So they can do something, but you immediately you will see that the state respond and then actually erase them basically. So then you see, I don't know, like, I mean, how many of them still dared out to protest in that way once this actually banned a better state, right? So the regional valuation, of course, is everywhere. So the point, as Dan and quite point out, is at the degree and extent, right? So there must be a variation. So even in the two courts I studied, like, I mean, how they assess those cases actually refer back, reprimand by the peer court is different. How they assess the mediation rate is different, and then actually that has an impact on how the judges make those decisions, right? So it's related to certain elements, but overall you still see the general pattern because of these institutional constraints. All right. So that's all my response to the regional variation point. And then again, that I want to really thank for the panelists and Ding, and also the participants for this session. Really grateful. And then I know that there are a lot of problems of the book, and then you just dare not to, you don't want to mention this scenario. Let me know that, and then perhaps there's a more lively discussion afterwards. Thank you.
Well, thank you so much, Xin, for producing this wonderful book. I would have to say you have to slow down a little bit, so otherwise we have difficulties to catch up with your scholarship. I also want to thank the three panelists for spending your time, really make a contribution to enrich the discussion, and Sida in particular, I know is after midnight. So thank you very much, and also the audience for spending the morning with us. So we're looking forward to other opportunities. So thank you very much. So have a good day and a good night.